Hello and welcome back. I've got attorney Mark O'Mara with me to discuss the Derek Chauvin trial. And we are at the stage of the closing arguments for both the prosecution and defense. Mark, you've been keeping up with the trial pretty steadfastly. Can you give me your thoughts so far on what you've seen today?
Well, overall, the whole trial, again, I have to say that the state did a very good job because they were very methodical in how they presented it. They started the case well with the emotions of it. The bystanders went all the way through. The experts really laid out what their position was as to cause of death and also that it was not appropriate use of force. And those were the two things, if you think about it, that they really had to address. They had to address it was outside the scope of what Chauvin should have done and that what he did caused the death. I thought the defense did a pretty decent job coming back and saying, well, it could have been this, it could have been that, could have been the meth, could have been the fentanyl, could have been asphyxia, could have been anything other than Chauvin's actions. Now we're at that point where, lawyers go to law school for this stuff, which is the closing arguments, where we think we actually convince jurors of a lot. In most cases, particularly the shorter cases, I don't see that closing arguments do a great deal of swaying. Although in a case of this magnitude and length, I do think that the closing arguments help focus the jury on what they should be focused on.
Yeah, the jury now has to go back. Well, I think we're just about to the end of the closing arguments, but the jury's going to have to go back and deliberate. And as I understand it, there's third-degree murder, there's second-degree unintentional murder, and then there's second-degree manslaughter.
Right.
Now, as the defense side is looking for this, what do you think the best is that they can hope for? Obviously, they're hoping for an acquittal, but what do you think their goal is here?
Well, certainly, what you really want to do as a defense attorney is just say, ladies and gentlemen of the jury, they just haven't proven their case to you beyond a reasonable doubt. If you have a doubt to which you're going to attach a reason and wondering what may else have happened or how else it may have occurred, then that's reasonable doubt. You should acquit. And that's just your standard, almost boilerplate criminal defense lawyer's mantra.
Mm-hmm.
But in a case like this, where the case for the state is so strong, I think that the defense has to be careful. If they walk in and go, they proved nothing, you almost lose your credibility with the jury. So you can't give up and say, please convict him of this. But what you sort of do is present it in a way where, get away from the second degree. That's the most serious offense. That's the one that sort of suggests that he didn't intend to cause the death, but he intended the actions that caused the death. And that's a very serious offense. The next one down the list is sort of this what they call third degree, what we call, the ill will and hatred. I didn't mean to cause his death, but I evidenced such ill will and hatred towards him that when the death occurred, I should be held responsible. What the defense really should be focusing on is giving the jury a sort of a path, a guide light where they may find just the manslaughter, which is this unintentional, maybe negligent decision or negligent act that ended up causing the death. I think that's the best that Chauvin can hope for in this case. And if the defense, without offering it up, if they allow that opportunity to be presented for the jury to consider it, that may be the saving grace for Chauvin, in that he'll be convicted, but he won't spend anywhere near the time in prison he would for the other two.
Right. And in a high profile case like this, the judge is really going to be pushing for them to come back with a verdict. They want to avoid a hung jury. Can you kind of get inside the minds of are there going to be jurors that are going to be stuck on one, higher offense, and then others that are arguing for the others? Are they trying to convince each other inside that deliberation room of what to go with that they can all agree on?
Yeah. So, well, I wish I had, a spy camera in every jury room that I've ever been involved in. That's against the law. So what we do is, in Florida particularly, you can't approach the jurors, but they can approach you. And I've had dozens of different trials where jurors have approached me afterwards. And yes, you're right. What they basically do is lay out the best case on both sides. And what it tends to happen is you may have people who do not believe that a conviction should occur, those who are voting or considering acquittal. But then you also have those people who want a conviction, but it's along the different categories or levels. And oftentimes I've seen jurors who will compromise their verdicts. A couple may want second degree murder, a couple may want third degree murder, a couple may want, or a few may want manslaughter. And what they may do is say, look, the judges told us to really try hard. We have to come to a decision. Nobody wants to try this case again, which is what happens on a hung jury. So they compromise, and they may come back and say, can we all agree at least on manslaughter? And if everyone can agree on manslaughter at the very least, maybe that's where they stop. If some really want second degree, then maybe they'll compromise to third degree murder. So I would anticipate that we're going to see somewhat of a compromised verdict here. And the reason why is I still think it is extraordinarily difficult to convict a cop of anything in this country. We've talked about some of the ones that I've had troubles with. And because of that, because there's going to be that inherent desire on at least some of the jurors' behalf to give the officer, Chauvin, the benefit of the doubt, that may lead to a compromised verdict.
Okay. Now, the defense this is their last chance in their closing arguments to really make any impression on the jury that they can. And they seem to bring up quite a bit of video that was brought out by the prosecution. What do you think about their decision to show this video, over and over in their closing arguments? That is really kind of the best evidence for the prosecution.
Yeah, that's such a double-edged sword, isn't it? Because, Nelson, on behalf of his client, he wants to get that video out and show a couple of snippets of it. And one example was when he showed, well, here's the picture that the prosecution showed you of the toe being off the ground, suggesting all of Chauvin's weight was on the neck. But let's look at the video. Maybe the toe wasn't up that long. And I guess you have to make those points. So yes, a defense attorney has to take that chance. The other side of that double-edged sword, however, is no matter what, that video is showing George Floyd, who everyone knows within 3 or 4 or 5 or 9 minutes is going to have passed. And you can't help but have empathy, sympathy in your heart when you're watching a video of somebody who is spending his last few minutes on earth. So it's very, very difficult. If it were me, maybe try and make the points somewhere else, but not constantly show that jury the state's best piece of evidence, the video.
Right. Now, this is probably one of the most high profile cases, maybe since one of the ones that you handled. And now the jury has to go into deliberation knowing that the ramifications of their verdict might have some effects on their city. There's a lot of, protesting that's going on. There's some expectations of what the protesters want. How much does that weigh on their mind? I'm sure that the judges told them not to consider anything, but we're all humans. What do you think is going through their minds?
It's very difficult. And we did that with the Zimmerman case, try to insulate them as best we can. But it is undeniable that this jury knows for the past year that this case is a focus of the community, the entire community, certainly the Black community, not only in Minnesota, but throughout the country. And they have to be carrying that weight on their shoulders. The hope is that they will do what the judge tells them, apply the facts to the law, and come up with a legal verdict. That's all we can hope for. My hope is that they do not fudge or hedge or change their thought processing just because somebody outside the courtroom may be looking, the general public. We hope and we tell our jurors, we will listen to your verdict, whatever it is. We will trust it. As long as you do what you're supposed to do, it'll be a legal verdict. And now it's up to the jurors not to allow those outside, call them societal pressures, to have any impact on a verdict.
Right. Any predictions based on what you've seen so far?
I really believe that it's going to be a compromised verdict. It's not going to be the most heightened charge, the second degree murder. I think that they may come back with a third degree murder as a compromise, sort of a almost nod of the hat to law enforcement in general. And, according to how much back and forth they have in there, according to how many law enforcement supporting jurors are in there, this may even go down to manslaughter. I think the facts support the second degree from my perspective, certainly the third degree murder charge. But we'll, the jurors are given the wisdom of having to sit through every piece of evidence, and more importantly, talk through it themselves. That's I will agree to this. I will trust their verdict, whatever it is.
Well, as if Minnesota hasn't seen enough incidents like this, right on the heels of this Chauvin trial, we've got Dante Wright. Same state. These circumstances are quite a bit different. Any thoughts on that?
Well, yeah, I actually wrote an op-ed piece within about an hour and a half of it happening. Before we even knew it was a female officer, I think I said it was a male officer, my own little implicit bias showing there. And I said what I really thought it was. There was no ill will or hatred with her, I don't think. But what people don't realize is in times of hyper stress, our frontal lobes, that part of the brain, where we do our cognitive thinking, it just detaches. We literally go back to that limbic part of our brain, this brain stem, which is the fight, flight, or freeze. And I'm telling you, if we had a video going on inside her head, I think that officer was thinking, something's coming at me. There is that implicit bias. It's a young black male. That just, we know from the Harvard implicit bias study that exists in all of us. I think she was thinking, protect yourself, protect yourself, protect yourself, even though her training was, this is not a gun event. This is a taser event. So her cognitive part is saying taser, 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 where the back part of her brain is going, protect yourself. And strange as it sounds, that's why I think she pulled out her gun, thinking maybe cognitively, if you will, that she was going for a taser, but that part of her brain that says, please survive, took over and had her use deadly force.
Yeah, and this is probably not the best relation, but the Tiger Woods accident, they showed through the data that he actually slammed on the gas instead of the brake. So as he went into his fight or flight mode, his first reaction was just press down hard. And instead of going off the road at 70 miles an hour, I think it's around 85.
Yeah.
So
well, we all do that. And, a really silly example, and I'm going to confess animal abuse here. My dog and I were playing like 3 or 4 months ago. He's a big German Shepherd. And we were just playing on the ground or whatever. And he just went up and his nose hit mine. And I thought he broke my nose and my face because he's got a pretty big nose. And in my hand I just slapped him, backhand slap him, no intent whatsoever. I'm not mad at my dog, but it was the smash to the face. I saw lights and I hit my dog. That wasn't intended, but it was the back of my brain going, something just broke your nose, maybe do something before you even cognitively think of it. And that, unfortunately, is the way the human brain for eons is meant to respond to a perceived threat.
now, last question, I'll ask you to make another prediction. Do you think there's any chance that the officer in the Dante Wright case pleads guilty? Everything's on video. I think it's a pretty clear case of her mixing up the two, or do you think they'll fight this?
My gut is that there was no intent by her. There's no criminal intent by her. I thought the charging decision was extraordinarily quick and was done more for social or political reasons than, well thought out legal decision making by a prosecutor. I don't think she should plead guilty. I think if there's some resolution that does not include her being incarcerated, maybe something like that. But, what is it, 15, 20, 25-year veteran with no other evidence of this type of animus towards the Black community, which I don't think exists. This was a horrible, horrible tragedy, but one that, because of our training of all officers and our training of each other societally, we know that we're all biased against young Black males, that if we don't address that issue, we can put every cop in jail we want to. We're going to keep having them come through the system if we don't train them better.
Right. Well, Mark, thanks again for your expertise and insight on both those cases, and we'll look forward to catching up with you soon.
It's been great. Good talking to you. Be well.
You too.